Welcome everyone to this presentation on an update to the purchase and sale contract for the Bluegrass Realtors. My name is John Rompf, and I'm an attorney at the law firm of White, McCann, and Stewart. I have had the privilege of working with both the Forms Committee and the Board of Directors on the development of an update to the purchase and sale contract that I am excited to share with you here today. Let me begin with a disclaimer by letting you know that neither this form nor this presentation are intended to be legal or tax advice regarding any particular situation or transaction that you may be involved in. I would encourage anyone watching this presentation to contact the appropriate professionals for any legal or tax questions they may have about the use of this form in any particular real estate transaction or situation. My primary objective today is to ensure that when you leave this session, you understand what has changed with regards to this form and how to confidently use the updated form in your work. I'd like to begin today with kind of discussing the high-level goals that we've attempted to address and achieve with this most recent revision. The first and primary consideration was to listen to member feedback and try to incorporate changes and recommendations from membership that was provided to staff regarding how these forms interact with their own personal experiences in dealing with the contract and negotiations in the actual marketplace. Obviously, on some occasions, these recommendations from membership were directly contradictory to one another. One person wanted A to see as a change, one person wanted to see B as the change, and those two things were directly oppositional to one another. In taking into consideration such situations, this revision is an attempt to incorporate as much of the membership feedback as possible, while at the same time making the form workable and usable for your daily practice. The next objective was really to move action items found throughout the contract to the beginning of the form. We received quite a bit of feedback from people that in the prior version of the contract, a lot of time was required, sometimes flipping back and forth through the contract to make sure that actual items were appropriately selected. And also, sometimes membership found that it was difficult to remember which boxes needed to be checked in certain situations. So the idea was to bring all action items to the beginning of the contract so they're more easy to locate, and also to allow members to know where those action items are going to be, so they make sure that no matter what their transaction, the specifics of it may be, they remember to fill in all of the appropriate action items. Another thing that we were hopefully trying to make better in this form was to make kind of all of our forms internally consistent with all the other forms found in the Bluegrass Realtors form directory. And one thing you'll notice is that we are really trying to use consistent language throughout all the form updates. Our long-term goal or objective is to eventually have a standardized definition section for all forms so that we can remove those definition sections from the forms themselves and create a separate document that can be a standalone instrument that people will kind of acknowledge the definitions that are applicable to all Bluegrass Realtor forms, so that those provisions don't have to be included in each individual form as they're updated. Obviously, this will be a lengthy process, but it's something that we're keeping in mind anytime we're updating a form. And then really the final goal with any update is to make sure that our contract remains legally compliant, that we're adopting really best practices for the industry, and that we're learning to adapt to deal with real life situations that you all encounter with how this form contract kind of relates to your general real estate contracts and then or situations and the specific circumstances you might encounter in your daily practice. So with all that said, I'd like to begin kind of highlighting some of these changes. I think the best way to really do that is to look at a red line of the former instrument compared to the new. The only unfortunate way of doing this is to kind of show those changes in red line. And one of the negatives of that is that the page numbers and the line numbers are not necessarily going to match up with the finalized version of this form and that I'm showing in today's presentation. But to make it easier to follow along, I'm only going to be referencing the line numbers that are shown on this red line version of the presentation and not the finalized form. So if later on you're looking back at this, the pages and line numbers won't match up necessarily with the clean version, but I hope it'll make it easier to follow along today. The first thing that I'd like to highlight to you is the top section of the contract, which is really a disclosure that's found on many of our forms. And the purpose of this change is to update not only you as members on the importance of consulting tax advisors when necessary, but also to allow for an opportunity for you to update your clients and the consumers by reminding them that real estate transactions can have significant tax implications, and that they need to not only consult legal professionals if they have legal questions, but also tax professionals if they have questions about how a specific real estate transaction may impact them on a tax perspective, and what the consequences of the transaction may be from the perspective of tax liabilities. We think this needs to remain kind of at the forefront of the agreement. It's a disclosure, and it's really aimed at letting consumers know, hey, we need to consult with these types of professionals to answer the questions we may have, that may be beyond the expertise of us as real estate agents and or legal counsel or tax advisors. These are all specific skill sets that are developed, and they need to consult with the appropriate professional and with the appropriate questions. The next thing that I want to point out is that areas that are shown in green on this red line are not items that were added or deleted, but they are items that were moved from somewhere else in the form. So the changes that you're seeing in green are actually something that was just moved from somewhere else. And this first one that I'm highlighting here is, if you're looking at lines 14 through 19, you'll see that we've moved the purchase price up to the very beginning of section 1. It used to be buried further down in the document. And the idea was, and this is based on a lot of feedback we've received, that the purchase price is obviously one of the most important parts of the contract, but it's also one of the things that is most frequently changed through negotiations. And the feedback we received from members was that it needed to be at the beginning of the contract, so it's very easy to locate. It's something that all third parties, appraisers, lenders, title companies, all need to have that information. It needs to be easily located. So moving it to the beginning of the contract, just from a logistical standpoint, made a lot of sense. The next change that I want to highlight for you is really dealing with all of lines 20 through 41. This is the identification of the property. There was really no change to the basic information in lines 20 through 24. The major change was really to the personal property that is included and incorporated into the contract. And you can see that most of those changes were just trying to abbreviate this section a little bit and make it internally consistent in terms of capitalization and spelling. But we also took the opportunity to broaden the terms where it made sense. So some of these items we're really trying to make it more encompassing rather than limiting language. So some of the areas were broadened. So for example, landscaping, we added exterior lighting to make it clear what lighting we're referring to. We utilized the phrase pool equipment to use a kind of very broad language. So I would pay attention to the changes in this section. Again, I don't think anything is counterintuitive or confusing in any way, but there were some minor changes to kind of update this to allow for more common things involved in transactions, and also to kind of abbreviate this section and get rid of some inconsistencies with regards to formatting. We do receive a lot of member feedback about this section, and honestly, this section alone could probably be 3 pages long, but one of the big recommendations and feedback we've received is trying to condense this document as much as possible. So we really tried not to expand this section, simply to improve it. The next change you'll see is to lines 42 through 44 at the bottom of the agreement, at the bottom of page 1 of the agreement. And that change, again, is really just a movement. It's not a substantive change of any type, but moving this information forward. Skipping forward to page 2 of the agreement, the next change you'll see is kind of in lines 50 through 52, and this is a big change. We have changed the word fixture to the word items, and membership kind of reported to staff that a lot of issues have arisen with the new contract and continue to rise, and this was in the old contract, about misunderstanding about kind of what items and objects qualified as fixtures in the legal meaning of the word. And the remedy was really to broaden that word so that sellers know They really need to identify any item they intend to remove from the property and to err on the side of disclosure. So this is a substantial change and will require folks to really consider what items need to be filled into this section. So there's clarity about things being removed, and there's not a dispute at the final walkthrough stage about such and such item was supposed to stay versus being removed, and really gives everyone an opportunity to be on the same page at the execution of the contract stage rather than waiting till later on where that can cause discomfort to the process and on occasion, delays or cancellations of closing. So it's a substantial change from a legal perspective, and folks need to be aware that this is going to broaden probably sellers' duty to disclose information at the contract phase. The next big change to this red line is looking at lines 58 through 66. Obviously, everyone is aware of significant litigation regarding cooperative commissions since the form was last updated. This change to this section are made both to make the document more consistent with our other forms, but also to make sure we're legally compliant by presenting an opportunity for consumers to be aware and educated about what their options and obligations are as it relates to buyers, brokers, commissions. The substantive change to this section is to add a blank box for other for commission or for no commission to be paid by sellers to the buyer's broker. Again, the idea here is to make the form consistent with our other documents and also to make it legally compliant and kind of based on the legal landscape as it's changed over the course of the last 2 years. The next change is found in lines 67 through 82. Here we have moved up the contingency section of the contract from where it was later in the form, again, with the aim of bringing that action item forward to the beginning of the agreement. One change was in line 79. This is a substantive change to add a contingency for a survey. As many of you are aware, surveys are often required for financing or maybe for title insurance reasons, and we wanted to have a checkbox available to parties to specifically select that the transaction would be contingent upon a survey rather than leaving that issue to be addressed in an addendum. Obviously, there'll be an occasion where an addendum may still be required for a survey contingency. And if those circumstances present themselves, a blank contingency form can be used and noted in the fillable box section here in line 82. Again, this is a pretty substantial substantive change, but it shouldn't affect the way people operate. This was something that obviously contracts were previously contingent on. It's just allowing it to be disclosed via a checkbox versus necessarily an addendum. The next change here is in lines 80 through 82. And this is just making clear how the contingencies relate to the rest of the PSA. It gives the opportunity for the termination if the contingency is not met, and it's really explicitly drawing our attention back to section 9A where that language is detailed. The next big changes are found on page 3. Here, kind of wanted to discuss a section that was added to the form this year. It's found in lines 100 through 106, and it has to do with the right of rescission. One issue that often comes up in transactions is that parties to the contract don't understand how specific types of buyer financing can impact the closing. And not only maybe the date of closing, but how funds are dispersed and how certain types of financing can impact both seller's right to disbursement, but also property, possession of the property being transferred to the buyer. And this section is aimed at providing an opportunity for disclosure to the consumers that if certain types of financing obligations are selected to and agreed to by the parties as part of the transaction, that the right to possession and the right to disbursement of sale proceeds can be affected by that. Obviously, this can come up in a number of situations. Probably the two most common would be if the purchaser is using some type of bridge financing or a home equity line of credit involving their primary residence. By adding this section, the opportunity is now here for agents to have conversations with their clients at the beginning of the process and for the issue to be disclosed to both the buyers and the sellers, and for all parties to understand how certain financing might impact the closing process. And that, after a full conversation, discussion about that, buyers and sellers can kind of initial here and have their informed consent to agree to that financing, knowing how it might impact them later on. The goal is to get everyone on the same page at the negotiations standpoint versus at the closing table, so that when the closing date is set, no parties are surprised, and seller understands they may not receive the proceeds immediately, and the buyer understands that possession may be delayed. If necessary, it'll give the opportunity for the parties to negotiate how this is going to impact things, and do that at the onset of the contract rather than at the closing table, as sometimes occurs. The next change is, again, it's lines 132 through 134 there at the bottom of page 3. Again, that is just moving an action item forward in the contract. This is not a substantive change, and it appears in green because, again, it was a movement. But the idea is, again, to move the action items forward, so that you're not having to dig through the contract looking for boxes to check, making sure we don't miss things later on. Moving on, the next change really is found on page 4. Here in the middle section, I've highlighted it's lines 152 and 155. Again, here we're trying to make our documents internally consistent and also practical. So we changed in the definition section for the delivery of escrow from 72 hours to not more than 3 business days, and then consistently there in section 2, the same change. As many of you are aware, sometimes in the negotiation of contracts, they might be signed on a long weekend or a banking holiday or a time when offices are traditionally closed. And that sometimes makes it very difficult, if not impossible, to comply with an actual 72-hour deadline. So we wanted to change that to make this process more practical, recognizes that businesses are often closed on Saturday and Sunday, and particularly financial institutions where these deposits have to be made. So we're trying to recognize, practically speaking, how people can comply with these agreements in situations where banking holidays may be in play. Moving down here to line 178, this change relates to the disclosure of condo certificates. We wanted to put a definite and quick deadline on that process. From a best practices standpoint, this is information that a listing agent most often has in their possession at the time of their listing. And because these certificates can affect financing or insurability or title, we want to make sure that that information is disclosed by sellers to buyers as early in the process as possible, if it wasn't provided at the time of listing, so that that information can make it to all the third parties who may rely on it. So insurers, title companies, banks who rely on this and making their decisions that have to be made during the due diligence process. We want to make sure that information is transferred as quickly as possible in the process. So just putting a definite deadline on that process. Kind of moving on to page 5. Again, very minor changes here. They're really just changes to numbering and lettering things. And this is, again, the result of moving action items forward. And I just kind of want to emphasize that was one of our primary goals. Obviously, people get used to the old form where things are located. It is a big change, we recognize, to move things, but we hope in the long term, by moving those items to the beginning, it'll actually cut down on the time spent looking for them throughout the form. When things are being negotiated and changes are being made, all those action items will be at the beginning of the agreement if you're using the form. The next really big substantive changes are found on page 6. And I would say these are some of the bigger changes that we made, and these are to the due diligence section, specifically subparagraph 4. And this is dealing with inspections, and we're looking again at lines 274 here through 282. And we've added a different kind of inspection that, again, it's a substantive change, but buyers already had the right to do these types of inspections because of the broad language in the agreement already. But this change is to make it abundantly clear that insurability inspections are something that buyers need to complete during their initial due diligence. And given changes in the insurance industries and companies' policies, it's becoming more and more frequent that obtaining insurance can be a more costly or time-consuming process, and certain insurances may be denied or become prohibitively expensive due to the condition of the property and maybe the need for repairs prior to companies being willing to offer certain insurance coverages. So sometimes these issues are very small and minor, but sometimes it may require something extensive like a roof replacement. And as insurance becomes more challenging in our marketplace, we wanted to have it kind of be an important disclosure to consumers to get these inspections done very early in the process. I know historically in this market, sometimes Consumers may wait until closer to closing to bind insurance, often waiting until their lender requires it. But as agents, this is going to require you to kind of educate your consumers about binding insurance, or at least getting it quoted very early in the process and not waiting, so that they know early on that they're not going to have to do repairs way after their due diligence time period has lapsed. So this change was really made to draw attention to this issue, so that agents are reminded of the importance of educating their clients about this issue early on, and kind of creating a presumption of such an inspection. Obviously, insurability affects a lot of things like financing, and folks need to know early on what their costs are going to be, and obviously to make sure that they can get insurance at all. So it's something that's coming up. It's becoming more frequent as the insurance industry changes, and it's important, I think, for us collectively to educate the consumers on how that impacts their due diligence process. The other change to this section was to specifically add the pest and wood destroying insects inspection to this paragraph. Obviously, the inspection is discussed in a lot more detail in section B directly below, and everyone is very familiar with that process, but we wanted to draw attention to it by adding it specifically to this section 4. And that's based on some feedback we received that sometimes this subsection is treated almost like a checklist by consumers. And so we wanted to be more explicit in identifying the wood destroying insect inspection here, so that buyers are knowing they need to start that process early on. And then looking here at subparagraph 6, this was added. And again, I'm looking at line 282 to this section to make sure that folks are referring to the end of the contract for FHA and VA financing requirements. Obviously, for those familiar with those types of financial situations, they require specific appraisal processes, and it's making sure that we're referring to those whenever they're applicable to our agreement. So it's just drawing attention to that during this due diligence period. Moving on, the next section, the change that is found is in section 7, which is on page 7. And this is relatively minor, but it's found here in line 331. And it's having to do with a disclosure to our consumer buyers about kind of the purpose of the title exam that's being done, and kind of further emphasizing through this disclosure that a buyer must obtain their own title insurance policy in order to be protected against title claims. I think most agents are familiar with how this process can play out, but for those unaware, in most instances, lenders will require title insurance, and purchasers will have the option to obtain an owner's title policy. And I know most of you probably recommend that to your clients. However, there are circumstances where lenders do not require title insurance, and in those circumstances, lenders often only require opinion letters from attorneys or title agencies. And in those circumstances, the borrower may not be protected at all by that opinion letter. And this change is just to draw kind of attention to those circumstances. It's an opportunity, this update really, to make sure consumers are aware of the steps they need to take in order to obtain an owner's policy or their own title opinion letter from the attorney or the title company if they want to be protected against title related issues. So you'll notice in our other forms that we've updated that in the new recommended contract phrases, we've added language to be used in an addendum in situations where buyers elect not to obtain a title insurance policy or a title opinion letter, that basically allows buyers to specifically acknowledge that they're not going to do so. And I think it needs to apply in situations with title insurance, but also in situations where there's just an opinion letter to make sure that your consumers are protected. The next change in the document is found in section 8, and this has to do with closing procedure. The change is to address situations where sellers did not want to necessarily cooperate with maybe providing all the information or requirements that lenders would need in order for a transaction or a specific type of financing to be consummated. And the idea here is we're adding to the contract in line 346 that sellers are going to be required to complete documents that are required not only by a title insurer, but also by a lender. And the idea here is to make the closing process as smooth as possible. Similar to that is the changes highlighted in lines 352 and 353. And this is talking about information that a seller may have to provide to a closing or settlement agent in order for that third party to remain compliant with the IRS. So those W-9s and the 1099s that may be requested from the settlement agency, making sure they get the information they need. One big change that has not been addressed in this form is many of you are aware that changes took place effective of March 1st of this year relating to FinCEN and the reporting of certain types of transactions to the federal government. Now that those changes are in effect, the Forms Committee is likely going to be working on an addendum to the contract to be utilized in situations where those apply. And sellers and buyers have the requirement to give additional information to settlement agents in order to be compliant with this new federal law. This is just a good reminder that these forms, no matter how hard we work on updating them and staying legally compliant, this form is going to have to remain a living document that's going to be changed, on a regular basis. We're going to attempt to limit updates to taking place on an annual basis, so that there's not multiple versions of the form floating around, and you have to be very careful about which form's in effect. We're going to be really careful about trying to limit the changes to once annually, but I would expect that we'll continue to have updates to this form as real life experiences play out, and we continue to kind of model best practices in the industry. The next change is found on page 9, and this is dealing with dispute resolution on lines 432 and 433. The contract previously created a requirement of where mediation would take place. And through feedback we've received from membership, a lot of times that location was not going to be necessarily convenient to people who lived outside of the central Kentucky area. So the idea is to allow the parties to continue to engage in this non-binding mediation as a dispute resolution mechanism, but to allow them to select the provider of their choice and not to presume that that's going to take place at any specific place. The next change is to section 10 of the contract in lines 436 and 437. Really, that's just a deletion of duplicative language, but I did want to highlight it as it is a change. The next change I'd like to discuss is to section 11. The change here is to make clear that the contract acceptance takes place upon delivery of the fully executed agreement versus receipt by all brokers. So delivery is when it's going to be kind of fully executed and binding. This change was aimed at addressing concerns about not knowing when it was actually received by all brokerages, and so making sure that the delivery of it is the final. This is likely not going to affect the way I think any of you operate, but in the case of dispute, it will allow for some clarity. And I wanted to just point this out because it only is a problem when it comes up, and make sure you're aware of this change. The next change, again, is not really a substantive change. It's a movement. This is the one place where I think we moved a substantial section to the end of the document versus the beginning. And that has to do, this is from a legal perspective, this clause plays a few roles, but one of its purposes is to clearly identify the scope of the agreement and limiting it to the terms contained therein. And the idea is logistically, it makes sense for that to occur at the conclusion of the agreement rather than the middle. So we thought it was important to move that from the middle of the contract down towards the end. So again, this section was not being deleted, it's just being moved. The next change that I'm going to highlight is in the new section 13. Again, the section numbers just changed because we're moving the former section 12 towards the end. And it's a change that's providing a little less information to consumers. So communication is going to, always probably be through the agents anyway. And this is probably things that agents were doing primarily for their consumers, not directly by the consumers, but it's going to require you to kind of educate your clients on the front end about what, their need to be in communication with you about their work on the appraisal or their work on getting inspections done. And again, this is mostly actions coordinated by agents anyway. And so it was an opportunity really to remove that, to condense the agreement a little bit, because we recognize that these are tasks really being handled by agents and the communications are being handled by agents. So it made sense. This was a place where we could kind of condense. And again, that was a primary concern of almost all the feedback. We didn't have any membership, I don't think, saying they wanted the agreement to be longer. So we were really mindful of trying to not make this agreement become 30 pages and to try to honor membership's request to try to condense it down. So that's part of why this change was taking place. The next thing I'd like to discuss is here in lines 526 through 543, which is the wire fraud disclosure. It remains very important to bluegrass realtors, obviously, that consumers continue to be updated on all the potential problems and risks posed by wire fraud in our industry. This change in language is not intended to be any kind of indication that this issue has gone away or lessened. It's actually gotten worse. But the new language is our attempt to be consistent in messaging with the National Association of Realtors related to wire fraud. So we've incorporated their language into the agreement. And again, it's also enabled us to condense this section a little bit. But the change is not in any way intended to be an indication that wire fraud is no longer an issue, but to allow the document to be more consistent with messaging our membership receives from other parties, and also to allow consumers to still know how important it is to be careful anytime they're having conversations or communications related to wires. The next change is, again, this is kind of like the disclosure at the beginning, but it's in lines 544 through 549. And again, we're just highlighting to the consumer the importance of consulting with their tax advisors prior to agreeing to any type of real estate transaction, so that buyers and sellers know way before they get to the closing table, or after they're, a year later when they're filing their taxes, the impact that the transaction may have on their tax circumstances. I hope that one of the main learning points from this presentation today is the importance of, encouraging consumers to get tax advice early on from their tax professionals anytime they are buying or selling real estate, so that later on they're not surprised by the implications it can have on their bottom line. They need to be doing that. That needs to be a primary consideration. One of our primary duties in educating our clients is letting them know that real estate transactions often have tax consequences. The last change you'll see on this page is to section 26. And again, this only has to do with VA and FHA transactions. As those of you who deal with these types of financing are well aware, these disclosures are required to be part of the contract. And our intent was to keep the disclosure in the main contract, but to, again, remove an action item from being on the last page. So the way we accomplished this was to remove the blank for the purchase price from this section, and instead to reference the section of the contract where the purchase price first appears. So instead of having a blank, we've got the reference back to line 14, so that you don't have to go back and change the purchase price in two places. So one of the things reported to us is the issues that arise where people might change the purchase price in one of the two places, where it ended up being basically an internally inconsistent agreement. We had two different purchase prices, and the idea is to remove the possibility of that happening, with the hope that we'll have less chance for complications in situations where the purchase price changes through negotiations after its initial execution, and making sure that the third parties who rely on the purchase price receive consistent information. And the last change to the agreement is a rather substantive one, and that has to do with the execution page. You'll note that here we've removed the rejection and counteroffer section from the contract. There were two really main reasons for this change. We received a lot of feedback that it was a common occurrence that the counteroffer was not being effectively communicated to third parties like lenders and title companies that it needed to be. In my own practice, I've experienced this too, where sometimes that page was left off, and it was a frequent enough occurrence where it was brought up a number of times that this would help facilitate those parties getting correct information. I think it occurs often. More often it was occurring where paper execution was taking place versus dot loop or other forms of electronic execution. But it was a frequent enough problem that it was causing problems in transactions. So the idea was to remove the rejection and counteroffer section from the agreement, and basically instead allow a new agreement to be executed. Obviously, anytime a rejection is done, it's pretty simple for a counter proposal to be proposed by a seller, and that can accompany a rejection. The end hope here is to create a cleaner form so it's clear what the final agreement is between the parties, without the need for a lot of initialing and redlining and going back and forth. And sometimes even in dot loop, when there was initialing and redlining, it was hard to know whether that was applicable to the initial execution or the rejection encounter. So the opportunity here was to try to clean things up, and we think this will make the form more clear. And when it makes it to third parties, it'll be finalized without a lot of issues. So we recognize this is a big change. This was an issue where some members liked the way it was, some really wanted to change, and we've tried to adopt the form now that really addresses the issues with third parties getting kind of conflicting or misinformation or things being missed, and obviously could impact buyers' financing opportunities. So the idea is to make the form cleaner, and the execution now, there's still the opportunity to negotiate, obviously, but the execution page here will be a much cleaner form. And really, I think, that summarizes all the changes we've made. And again, the goal here was not to do anything really other than to incorporate member feedback and make sure we're being responsive and getting changes in the forms that are necessary. Obviously, we're trying to keep it legally compliant and up to date, and then be just responsive to individuals' concerns with how the form plays out in real life circumstances. So I thank you all very much for your time today. Obviously, I think this form will continue to have changes throughout, the coming years, but we hope that this update addresses a lot of the concerns that membership have, and also allows us to adopt some of the best practices in our industry. I thank you for your time, and I wish you best of luck this year in all of your endeavors. Thank you.